From the offices of Dickie, McCamey, and Chilcote, this is the DMC Report.
In late April, the Federal Trade Commission banned non-compete agreements between employers and employees meant to protect proprietary information and company secrets from being shared with competitors. The Biden administration says the ban will promote competition, protect the fundamental freedom of workers to change jobs, increase innovation, and lead to new business creation. It will impact about 30 million Americans if it passes a growing list of court challenges. So what should employers do now? What rights do they have? What does it mean for existing non-compete agreements? And how can businesses protect their proprietary information within the boundaries of this new rule? Here to break it all down for us are our favorite labor and employment attorneys, Wedell and Shaka Sadler from the Cleveland office of Dickie, McCamey, and Chilcote. Kristin has over 20 years of experience in the areas of business and labor law, civil rights, workers' compensation, and product liability, and is a certified specialist in labor and employment. And Shaka Sadler handles a wide range of complex and employment matters, including discrimination disputes, wage and hour cases, union grievances, employee discipline, and reductions in force. And both Kristin and Shaka are joining us today from their offices in Cleveland, Ohio. So, Kristin, let me start with you. What and who are non-compete agreements intended for?
I mean, it's a contract between an employer and an employee that would, upon the termination of the employee, voluntarily or otherwise, prevents the employee from going to work for another competitor or from from starting a competing business for a period of time, after the employment term ends. So really, when we look at the employment agreements, which are the non-compete agreements that were always drafted by the employers, they're designed to protect the employer's trade secrets, confidential, proprietary information, that the employee has learned through their employment with the employer. The contracts or the agreements are usually limited in duration, could be 6 months, a year, 2 years. Way back when, I've seen non-competes for 3 years and even 5 years. But times have changed then, as I'm sure we're going to talk about. But anything that's deemed to be too burdensome on the employee over 2 years, just as a catch-all, usually is not going to be enforceable by the court. So, in addition, though, to the duration of the contract, which covers the employee post-termination for a certain period of time, it's also usually limited by geographical scope. It could be limited to going to work for a competitor within 30 miles of the employer's place of business, 60 miles, some are statewide. The agreement itself, too, also is supposed to be narrowly designed, so it's in scope. It's not going to prevent the employee from going to work anywhere or in any business. It's really designed to protect the employer's particular business and line of work. So, one of the other things that we look at too on the employer side is, do we need to identify competitors? Well, we're not going to list them by name. What type of business, the time period, duration, and if an employee violates the non-compete agreement, the employer could seek damages and or file a lawsuit. And a lot of times this, it doesn't get that far, but the employer learns that the employee is working for a competitor or opening its own competing business using knowledge it gained from the employment agreement or the employment arrangement. And so the employer will seek an injunction and file a cease and desist letter, send a cease and desist letter and try and protect its confidential information. And this really is designed, the theory behind non-competes are to protect the employer's proprietary and confidential information.
With those kind of restrictions in force, what kind of effect had that had on the job market and employee mobility?
Well, a non-compete could be pretty restrictive, for the employee. If we're looking at the employees, where are they going to work? So a lot of this was designed for financial type of services, intellectual property, IT work, manufacturing, and really business related lines of work, right? So corporate management. And if an employee is bound by a non-compete, whether it's a certain period of time or geographic location and certain scope of type of work, I mean, it really can prevent an employee from being able to get the type of job that the employee's trained for, and has a level of expertise.
So tell us about this FTC ruling. What are the key points in the ban?
So FTC, the key ban, I mean, it's going to be shattering because the proposed new rule, the final rule, would ban non-competes out altogether, right? And that's except for senior executives. So if you have an existing non-compete agreement with a senior executive, that's fine. But going forward, if that rule goes into effect, then that exception goes out the window. So you can, as an employer, you will not be able to get your employees with a non-compete agreement, whether it's senior management or otherwise. And there's some small exceptions, but really for the vast majority of employers and employees, the new proposed rule will ban non-competes outright. You're no longer being able to enforce a non-compete or have an employee sign a non-compete. Your senior level executives are okay right now if you have a non-compete with them, but even hiring a senior executive, if this rule is in effect, you will not be able to limit them with a non-compete.
So Shaka, let's turn to you. This ban on non-competes was widely anticipated in the labor market for quite some time. But can you explain the rationale behind the FTC decision? What were the main concerns that they were hoping to address in the ban?
Okay, so according to the Federal Trade Commission, the decision was made in an effort to promote competition, also by banning non-competes nationwide. The commission was seeking to, as it claims, to protect a fundamental freedom to change jobs. The commission was also concerned that non-competes had a negative effect on the economy at large, and it kept wages lower than they could have gone and suppressed new ideas. The head of the commission actually made a statement saying that getting rid of non-competes as a whole would bring in about 8,500 new startups a year. So that's what it was really seeking to do. Whether or not it's going to create that many, new businesses, that's yet to be seen if it survives the challenges.
So on the flip side, how will it affect both employers and employees?
Okay, as far as employees go, and that's, again, although there are legal challenges that still remain against the final rule, it's going to affect a wide variety. In fact, most employees are going to be affected by it if they were ever kind of subjected to a non-compete. It's going to give those folks more flexibility in changing jobs or going into entrepreneurship. However, it doesn't give them a free pass to just use trade secrets. It will allow more flexibility for employers, pending the legal challenges that may put the entire rule at bay completely. There are still things that they should be doing now. First and foremost, getting legal counsel involved as early as possible at this point. Just kind of setting internal deadlines for compliance schedules if this rule does roll out and becomes completely enforceable. Better to be proactive than kind of lagging behind. Making strategies to protect one's trade secrets and goodwill is also essential, and trying to find ways to do that without the need for a non-compete. And there are avenues to do such a thing. NDAs are an example of using another mechanism that wouldn't be prohibited under the rule, as long as it doesn't function as a non-compete. And an attorney can help craft that kind of document that would be compliant and help employers move forward. So there's going to be an impact if the rule gets passed. So employers should prepare for that now.
Did the FTC carve out any exceptions or specific industries where non-competes might still be permitted?
It did, as Kristin mentioned earlier. Senior executives, if they're subject to a non-compete right now, they, it's still enforceable, but going forward, it won't be. As far as industries, there are a few industries that are beyond the scope of the FTC Act, and that would be nonprofit entities, certain banks and saving loans institutions, common carriers, air carriers, foreign air carriers, persons subjected to the Packers and Stockyards Act. So those would be a few exceptions from the rule, just because the act itself doesn't cover those institutions and industries.
So let's get down to brass tacks here. What is it that employers should start doing now to ensure that they're in compliance when the rule goes into effect?
So, like I said, we should really get those employment counsels on the phone right now. So, if you're watching this and you're an employer, pause it, get up and call your legal counsel. And if you haven't spoken to us yet, give us a call too. So that's really essential to compliance, is just kind of forethought. You want to look at any kind of standard onboarding procedures too. A lot of times that's missed. If you have even a HR department that's, just rolls out paperwork for new employees, you want to grab those folks first. You want to make sure that the non-competes that you have, if there are any that are just kind of standard to the process, are evaluated. You want to have legal counsel look at the language of those existing non-compete agreements, see if there is something that the employer could use to protect its secrets that isn't, under the gun from this new rule. Like I said before, non-compete agreements, non-solicitation agreements are also not prohibited by the new rules. So you want to craft some language that would protect your interests, but at the same time not function as a non-compete. Because then you're just catching yourself in a loop. It's still going to be seen as non-compliant. Something else that I'd like to mention specifically, what you don't want in new provisions of any contracts or anything else of that nature is any provisions that require employers to be reimbursed for training expenses or anything else. So you don't want that in the new language of any kind of NDA or any kind of non-solicitation. So that would be my advice and best practices going forward for employers dealing with this rule.
So there are still some things employers can do to protect proprietary information in the absence of a non-compete agreement.
Absolutely. And just knowing that, even though non-competes are being challenged, very well may, it may, succeed in its legal challenges and become enforceable. But in those cases, it might be best to just kind of look at that now. And if this rule does become enforceable, then, go full steam ahead. NDAs, non-solicitation agreements, that may be the way to go. However, doing it on your own and crafting that language might be more risk than, it's worth the reward here.
Kristin, what do we do now about the 30 million Americans who are currently bound by non-compete agreements? What do we do about them?
Well, one interesting thing about the FTC final rule is that it requires that employers have to provide notice to their employees that the non-compete will not be enforced. So, and actually under the proposed rule, they were going to require employers to rescind them outright. But so if you're an employee and you think you are, or you are, you have, if you're thinking about transitioning jobs, look at your contracts, look at your agreements, look at your onboarding documents that Shaka just mentioned, and find out if you've got a non-compete agreement in there, because, you can go to your HR department then and find out, if you're, and a lot of times this is not practical, if you don't want to give notice you're leaving or you're thinking about leaving, you probably need to look at legal counsel too and find out, am I a senior executive? Is this going to apply to me? Or are there other clauses in contracts that may be covered under the non-compete, even if it's not called a non-compete, because the definition of non-compete under the FTC rule is pretty broad. It's just basically anything to penalize an employee, or it's to restrict or prevent them to, from securing additional work. So on the, on the employee side, look at your contracts, seek counsel and find out, because your employer will have to provide notice that your non-compete is not going to be enforceable. And that's going to take place within, they only have a window between the time that now that the rule's now being challenged and it goes into effect. So if it goes into effect, the employers have to get those notices out, which would be, if it goes into effect, it would be September. So between now and September, is the time to find out whether you're covered by a non-compete agreement. And if you are, whether that's going to be enforceable or not. So, and then one thing that Shaka mentioned with the NDAs or the non-disclosure agreements or the non-solicitation agreements, if you are a high-level executive that's looking at transitioning jobs, you need to look at those specific clauses as well and make sure that you're not running afoul and be subject to litigation. Because as you mentioned, that the rule would still allow an employer to enforce a non-disclosure agreement to protect its trade secrets and to, non-solicitation agreement to prevent you from poaching their employees to come work for you, or, after you've left to start, poaching current employees. So there's only, so if you are looking at transitioning jobs, you need to look at your paperwork and find out and, and really examine and seek counsel if necessary to find out if you think that you're going to be subject to a non-compete or not.
What about state law? Does that complicate this matter in any way, or does federal law supersede the state law when it comes to these agreements?
So federal law, if it applies, if it's in the jurisdiction of the FTC, that's what's going to be the subject of all the litigation. But assuming it fits into the FTC box, it will preempt any state laws. So if there's a state law that's more prohibitive or allows non-competes or, more restrictive, that's going to be completely preempted. The rule would still allow, it's not a case in this particular case. I can't imagine a situation where a state law would be broader or less restrictive than the FTC rule. But assuming that would be the case, then it's not going to, it's not going to conflict. But California has an outright ban on non-competes, so that state law is fine. But anything that attempts to even restrict, in the slightest bit, either category of employees that'll fit into that category or, anything like that, the FTC rule is going to preempt it. So no non-competes in very limited circumstances. And even if it's a senior level, like we talked about, that you have in place right now, new employees are not going to be subject to a non-compete. That's not going to be permissive.
Okay.
So,
well, looking ahead, do you anticipate any challenges to this proposed ban?
Even within 24 hours, I read, after this FTC rule came in place, Texas and some other states have filed actions seeking a declaratory judgment that this is unenforceable, it's too restrictive, it violates the Fifth Amendment, that, FTC doesn't have the power to put an outright ban, like this, on non-competes. And so really only time will tell, right? It's going to be litigated on so many different levels, whether the FTC has the power to put this rule into place. And if it does, what is considered, it seems to me, looking at the language right now, that if the language right now as stands, which is you can't penalize an employee, you can't function to prevent them from finding, alternative work. And those are pretty, the language and the rule is pretty broad. So if it stands, I think we're looking at only very limited situations where you're going to be able to have a non-compete. So, and one thing too, on the employer side, you have a small window of, right, if you've got senior level executives that are not subject to a non-compete right now, there's nothing to prevent you from trying to, trying to convince them to sign a non-compete. Whether you offer incentives to do so or other things like that, you can do that. Like if your senior level executives subject to a non-compete as of the timeline that this comes into place are going to be covered. But moving forward, yeah, I think employers are really going to have a hard time. I don't think they're going to, if the language in the rule falls as it is, and it preempts all state laws, I think it's going to be very difficult for an employer to craft anything that looks like a non-compete.
Yeah, good point. Well, there's certainly a lot to unpack, but our thanks to you, Kristin and Shaka, once again for helping us make sense of this. We always appreciate you taking time from your very busy schedule to talk to us. Kristin Wedell and Shaka Sadler from the Cleveland office of Dickie, McCamey, and Chilcote. Thanks again for another great discussion. I'm sure we'll see you both again soon.
Thank you.
Thank you.
From the offices of Dickie, McCamey, and Chilcote, this is the DMC Report.